My history is part of the talk. Oh, okay, got it. So I'll go through a little bit of my history as part of this. So today I've been asked to talk about data and settlement. And so thank you very much to all the organizers for inviting me. Once upon a time, I imagined that I was going to give a lecture, and you probably know the term elevator pitch. You know, you have the amount of time it takes to be on an elevator with somebody, and you have to explain everything just in the course of, riding up and down for a couple of floors. And I decided that elevator pitches were a little bit too long for me. I wanted to have a fire drill speech, and the idea of a fire drill speech was that before I gave a talk, if there was a fire drill at the beginning of class and everybody was going to run out and, probably not going to get back in time for the class to reconvene, all I had was the time to yell my message at them as they were leaving the room. And so I felt like if I couldn't distill my point down to a fire drill speech, that I wasn't ready to give a talk. So I'll tell you, my fire drill version of this is that in my field, I wish data mattered more. Okay, so I'll just start there, just so you know, and we'll work through a wide variety of contexts in which I'll describe how data has worked and what, if not data, what ended up controlling the conversation. So the first thing is, let me give you a little bit of a sense of my backstory. I'll start with the present and then go back to the beginning and kind of move forward. For I guess about 31 years now, my full-time occupation has been either teaching people to resolve disputes or resolving disputes. I taught in a law school and mostly in legal environments. And so a lot of what I do is resolve disputes that are either currently filed in court or are imminently going to be filed in court. So that's sort of what I've been doing for a very long time. For 25 years, I was a tenured professor teaching in a law school, a couple of different law schools. And for the last 6 years, I've been one of the 11 people who run a company called JAMS. JAMS once was an acronym, and the acronym stood for Judicial Arbitration and Mediation Services. We are the largest provider of those services in the world. And chances are anything that you've read about in the newspaper, we've done. So you've heard about Enron, we did Enron. You heard about that leaning tower in San Francisco where, whatever, this is one of the most expensive residential buildings ever constructed, started leaning to the point where executives who bought apartments at the top floor were seeing golf balls that they were putting on their little home putting greens just roll into the corner. And turns out the whole building was leaning. So we resolved that. The Amtrak train that rolled over in Philadelphia, we did that. There's all the California fire cases. I'm working on those now. The Kardashian and Kim West divorce, the Kanye West divorce. We're not supposed to say that we do celebrity stuff, but that's all very secret. But chances are, if you've read the news and there's a dispute and it was resolved, there's a very high probability it was us. You remember, like Trump University, we did that one too. That condo that collapsed in Florida, we're probably doing that. We did a lot of the Hurricane Katrina cases and a million things that you never would have heard of, right? Personal injury cases, people suing doctors, sort of various political things, the Wells Fargo opened too many accounts, bank cases, on and on and on and on, right? We are kind of the big entity doing that. We're only about 40 some years old. It started with a judge who was a trial judge, a guy named Warren Knight. And at some point he said, I could be doing better for the world than waiting for them to try cases. I could probably get in and settle 5 cases at the same time it would take to try one. And so he started in a little strip mall in Southern California with just a 1-room office. And now, like I say, we have 29 offices in different US cities and a global presence as well. There are 11 senior managers, including the CEO is one of the senior managers. And, we have a pretty typical senior management team. Like one of our senior managers is in charge of IT. One of them's in charge of hiring and human resources, one in charge of marketing, somebody in charge, we have a general counsel, somebody in charge of what we call operations, which is the day-to-day practice of the business. I'm the only one on the senior management team who has been a dispute resolver, like that's what I do, and the only one who teaches. And so my job is making sure that everybody is trained up to their task. So that's a little bit about kind of what we do. How did I get there? Well, it wasn't like a job I even knew about. When I was a high school kid, I was really good at math, and I really liked math. And the reason I liked math was because questions on exams had answers, like real answers, right? And I could tell that after like struggling for a while, if it summed to 0 or 1 or -1 or something, I was like, great. I knew I got it right. Because like when things could have worked, they're very complicated and they get to a simple answer. And I loved that. And I remember once being asked on an English exam, discuss themes of color in Dr. Zhivago. And I was like, there's no answer to that. There's just no answer. That's not like a, I mean, you could just make stuff up. And we used to joke and say, you win the Golden Shovel Award if you get an A, right? Because it's just all kind of like shoveling something onto the, no right answer. Well, at some point when I got to college as a math major, and they started to reintroduce error, and now all of a sudden the answers weren't 1 or 0. They were like 1 plus or minus something, or 0 plus or minus something. I decided, okay, well, if I'm going to now be plunged into the world of uncertainty, I'm just going to plunge in head first. And I became a Russian major. I did a lot of theater, and I started just like figuring out what the humanities were all about. I ended up in law school afterwards, and law school was a nice synthesis between mathematical rules and the messiness of the social sciences, right? It was basically like trying to put some order around the behavior of people. And when I got out of law school, my first job was as a prosecutor in a very big DA's office in Eastern Massachusetts. We had about 300 lawyers, and I spent about 4 years there, probably tried several thousand cases, probably 100 jury trials, a lot of appellate work. And it was so busy that we didn't have time to think about what we were doing. We just did it, got ready for the next day and did it. I knew I didn't want to do that forever. And I thought, I don't know a lot of happy lawyers, and I wanted to be a happy person. So I had to have a role model. And the only people that I knew who were really happy, who were in law, because I was a first generation lawyer. My parents immigrated to this country, and so I'm a first generation American. So we didn't have a lot of professional friends in my circle growing up, but my teachers, my law school professors, seemed to be very happy people. And so I went back and asked some of my favorite professors, how do I become a professor? And I started down that path and writing and kind of working that way. My first job was in academia, was the one that was described earlier, where I was the associate director of the Stanford Center on Conflict and Negotiation. And we didn't talk about socioeconomics then, but we were doing socioeconomics. There were 6 principal investigators. And I'm going to name some names, and maybe you'll have heard of these people, but my job was to keep their grad students away from them. They said, if you have somebody asking a smart question, we want to know it. If somebody's asking a dumb question, you answer it. And that was my first job in academia. And I was like, I'm at Stanford, and your grad students are 5th-year PhDs, in fields that I haven't studied, it's not going to be easy for me to tell a good question from a dumb question. And they said, well, you're a smart guy, figure it out. And so I spent time now. And so who were the principal investigators? Well, a guy named Bob Wilson at the Stanford Business School is a game theorist. And maybe you heard of Bob because last year he won the Nobel Prize in economics. And I worked for a guy named Ken Arrow, who was an economist, who maybe you heard of him because he won the Nobel Prize in economics. I worked for a psychologist named Amos Tversky, whose research partner was Danny Kahneman. Amos died when he was 59 of cancer. Danny went on with their research to win the Nobel Prize in economics, which is amazing because he's a psychologist, proving that the rational model that underpins the economic, the rational theory of decision-making was not something particularly well suited to human beings, right? That we are always kind of veering off from rationality. Okay, so you had among the 6 principal investigators, 3 who either won or would win a Nobel Prize, and then 2 amazing lawyers, a guy named Bob Mnookin, who now runs the Harvard program on negotiation, and a guy named Ian Ayers, who's a behavioral economist teaching law at Yale. And our last person was a psychologist who recently passed away named Lee Ross, who, if there were a Nobel in pure psychology, he would have won that. And so here I am with these 6 amazing people from various disciplines, and all they wanted to do was figure out how do we make decisions better. And so we started talking about kind of all of the different inputs into making a good decision and all the distortions that lay between normal humans and a good decision. So I worked there for a couple of years, and the psychologists really explained my time as a practicing lawyer and a trial attorney better than did the lawyers, better than did anybody else. And so I fell in love with decision-making, socioeconomics, and in particular psychology. I also know that, if you spend enough time in psychology, or at least cognitive and behavioral psychology, there's a lot of branches. And for me, I was only looking at the branches that related to how a decision gets made. And so if you spend a lot of time there, you're also going to, at some point, encounter neuroscience. And a lot of neuroscience is all about, sort of curing disease, and, as it should be. There's a lot of issues with the brain, and, I hope that people figure out cures for Parkinson's and a whole variety of other ailments. But the part of neuroscience that I cared about was understanding the automatic processes of the brain, so we could understand how decisions get made on a sort of automatic, unconscious level. And so, if you're trying to think, how does a decision get made? Well, there's inputs from a lot of different fields. And I think that those fields primarily are economics, because that's a study of how to maximize utility, how to get the most of what you want. But economics by itself is a little bit stale, right? And a little sterile. And so we have to do what you've all done and add sociological elements to it. I think the second field that I care about with respect to, the world of applied decision theory is psychology, because we systematically and consistently depart from the rational model. For example, we know that losses loom larger than gains feel good. Think about how many A's you've gotten and how quickly you've said, okay, that was fine. And then you get an A- or a B, and you're like, oh my gosh. And that lives with you for a long time. 100,000 teachers tell you you're an awesome student. One of them says something that's less good than that, and you live with the loss, right? So, for example, one of the principles of, psychology, losses loom larger than gains feel good, drives a lot of behavior. And we also know, in addition, that whether something's a gain or a loss is often an artifact of where you draw your baseline. So economics, psychology, game theory. Game theory is a really important study, because you need to ask yourself, what's my strategy when I'm in a negotiation or trying to resolve a problem? Is the other person my ally or my adversary? And so there's a lot of really great information. I'd all commend to you to read the book by Robert Axelrod called The Evolution of Cooperation. Really terrific work talking about how cooperation can thrive in environments that are inherently competitive. And so, game theory is the third discipline. A fourth important discipline is what we'll call negotiation analysis, understanding three very basic, simple questions. What do you want? What's available? And what happens if there's no deal? If you read the most famous negotiation text of all time called Getting to Yes by Roger Fisher, one of my former teachers, then they call it interests, options, and alternatives. And so, that's a very important part to say, okay, so once you've decided your strategy, how do you approach the negotiation? And, there's a nice method there. We also include cross-cultural studies, and I'm a big fan of Geert Hofstede. I don't know if you know about Hofstede. He talks about cross-cultural dimensions, and to the extent that you live in a diverse environment and you work with people from around the world, you've probably seen things like, an example of a project I was working on recently where there was a Hollywood producer and a set of Hong Kong investors. And I'll just say euphemistically, a firm yes in Hollywood might mean something different in Hong Kong. Because in Hollywood, they're just trying to get an efficient answer really quickly, kind of very Western, very pushy, and they're not thinking about saving face. The Hong Kong investor might say yes to something because it's not really appropriate culturally to say no in a certain way in a meeting. And so, Hofstede studied collectivism versus individualism, power structures like power distance. Like in America, we talk about our presidents and we call them like, Barack, by first name. In other countries, power distance is a little bit different than that. And, that's not something that people would be comfortable doing. Right. So Hofstede had a number of factors. And so that's obviously his work, and cross-cultural work is a hugely important aspect of decision-making. So is just interpersonal skills, communication skills, the ability to get your point across, the ability to engage in active listening, some very important dynamics. We also talked about something called dispute systems design. In dispute systems design, we say, all right, well, what happens if it's a complex problem and you need to have multiple conversations and somebody needs to decide which conversations happen in what order, who's talking about what, when. And so, the big structure of problem solving has included a big element of dispute systems design. And then we talk also as well about abnormal behavior. And so, there's a number of inputs that really go into applied decision theory. And so we take inputs from a set of sub-disciplines, selected insights out of a set of disciplines. And like I say, primarily, the one I neglected to mention, the eighth one, law. When I was working in a law school, and some of my colleagues would say, if you're lecturing about psychology and economics of decision-making, why are you in a law school? Why are you teaching here? And I would say, well, because when people have a problem, they don't go to an economist or a psychologist, they go to a lawyer. And besides, the psychologist or the economist, even if they were sitting as a mediator, might not understand how to construct a legal settlement. And they don't understand the walkaway alternative. If the walkaway alternative is somebody sues somebody else, somebody at the table needs to say, how long is that going to take? What are your risks? How much is it going to cost? How likely are you to get what you want if you win? Okay, so that's a bit of my backstory. For the next 22 years after I left Stanford, all I did was teach and write in those areas. And then 6 years ago, I took a job full-time at the company that I work for so I could kind of be where the rubber meets the road and we could actually resolve disputes. So let me talk to you about some disputes I've been involved in and the role of data. I would also invite anybody who wants to please raise your hand at any time. You can raise your virtual hand, and I'm sure you're very good at that. And we can stop and take questions along the way. But I'm gonna walk through some very interesting disputes that I've been involved in and talk about the role of data. One is called Opal Creek. And Opal Creek is a 35,000 acre wilderness in the state of Oregon. It is the newest wilderness that's been created in the Pacific Northwest, and it's about 20 years old. You can find there's a book on the topic called Showdown at Opal Creek, as long as you're putting books in the chat, and a very famous movie actor, I don't know if you know Paul Newman. Paul Newman and the Sierra Club made a documentary about Opal Creek. It had been a 30-year fight over whether a particular very pristine part of the Pacific Northwest forest was going to be cut down. And the dispute got to the point where the son of a sitting governor who had recently returned from Vietnam and whose family owned some land up in that area that would become wilderness was so incensed at the idea that it was going to be cut down that when the Forest Service chief came out to mark trees that were going to be cut, George Atiyeh, the governor's son, held him at gunpoint and made him drop to his knees, put his hands, it was a big deal, right? When like a sitting governor's son holds a federal official hostage to prevent trees being cut. So Opal Creek spent 30 years question about whether it was going to be preserved or not. Well, why would it be a question at all? Well, when World War II was done and the GIs, the soldiers were returning home and they wanted to build houses for the returning GIs, where did they get the wood from? The Pacific Northwest, right? I mean, we were like the place that supplied most of the trees that turned into the most of the houses that most of you are living in, because we have pretty amazing trees. And the federal government said to foresters, hey, if you'll move out here and you'll relocate, we will provide you the raw materials from the federal forests. And so the town of Mill City was among, I mean, really imagine, right? Mill City, this little town in the middle of nowhere surrounded by nothing but big trees, basically arose to supply America's timber needs. Now, 30 years later, after a lot of things have been cut down and preservationists started to say, now, wait a minute, you're about to cut down a 1,000-year-old tree. We need to figure some way to preserve this stuff and still have houses somehow. And so if you like wood floors, if you like toilet paper, if you like anything made of wood, that started as wood, you have to be sympathetic to the idea that it comes from somewhere. And it might as well come from the place where trees grow back faster than anywhere else. And on the other hand, do you really want to feel good about like cutting down a 1,000-year-old tree, one of the oldest living things on the planet, so that you can have like a toothpick or a pencil? So big battles and, like I say, guns drawn. So Opal Creek became a big thing. I was the mediator for the final resolution of that, where ultimately we had to figure out how to pull land from existing wilderness, from other areas, to create an intact watershed. There was a Superfund site on the property because there had been a copper mine, and when they were pulling copper out, they use various chemicals to remove copper from the stuff they find it in. And then there are what are called mining tailings, which are highly toxic. So we had local government, state government, federal government, We had people from the Forest Service, people from the timber industry, people from the jobs sector, people from environmental cleanup. We ended up with 26 people in a working group, and then we had to have large public meetings where we would have 400 or 500 people at a time testify. It took about 8 months to craft a piece of legislation, and that legislation got rammed through. Opal Creek became like I say, the newest, most magnificent wilderness in the Pacific Northwest. And 2 years ago, it basically burnt to the ground. Right. So we preserved it, and climate change. Now, there was so much data. You want to talk about the role of data? There was data and data and data. How many trees of a certain age were left in the Pacific Northwest forest? What is an appropriate level of cleanliness for water to assure that the Superfund cleanup site had been cleaned up adequately? I mean, the effect on the timber economy and the local schools and education and alcoholism, right? Because people said, hey, look, you can't just sort of give money to the former timber workers, because they pointed to a town in California where they did that, where they just said, look, you can't cut trees anymore. We're going to give you money and you can retrain yourself. And rates of alcoholism and domestic violence skyrocketed. And so people wanted to draw lines between, like, this tree stands and this amount of domestic violence occurs. There was so much data, and I was, I guess, burdened or privileged, depending on how you want to think about it, with boxes and boxes of maps and books, and there was so much data that it ended up being data smog. The way that this was going to get resolved was going to be through the sheer force of will of senior politicians, Mark Hatfield being, Oregon senior senator at the time, who had spent most of his political career facilitating the extraction of trees and minerals from Oregon's natural bounty. It didn't want to go down in history, could see that his legacy was going to be one where he was going to be seen as basically on the side of industry. And so late in his career, he just became a preservationist. And he was just looking for more and more things to preserve. But for Mark Hatfield's seniority and force of will, it's hard to say that data would have moved the needle. So my first massive, massive dispute, and it was one that I'm really, proud of, was filled with people supplying data and politicians and a general public who didn't care. Paul Newman making a documentary called Rage Over Trees. Just fire people up. I mean, you're probably watching today's politics. Is it about data or is it about perception? Right. And so, humans being humans, it wasn't that different 30 years ago when we preserved Opal Creek. It really became kind of more about power than about data. Okay, let's move on. The next case that I want to talk about is called Pickford v. Glickman, P-I-G-F-O-R-D. Thomas Pickford was a Black farmer in the southeast of the United States, and Glickman, and Dan Glickman was the Secretary of Agriculture. So Pickford v. Glickman, known colloquially as the Black Farmers case, is the largest civil rights settlement in US history, with so far more than $1 billion paid out. And it was claims of discrimination by Black farmers in a selected set of southern states for 15 years of discrimination by the United States Department of Agriculture in the administration of farm loans. And so we heard lots of stories about Black farmer walked down to the county office and said, I want to file an application for a loan. And they said something like, well, we don't have any applications, or it's hard to do, or whatever, dissuaded. And then white farmer neighbor walks down to the same place, gets the loan right away. And so there was a class action. Like I say, the U.S. Department of Agriculture settled that case and said, we're going to come up with a payment scheme whereby people who can prove a certain level of damages will get whatever they prove, and other people who say, you know, I walked down 30 years ago to the ag office to ask for a loan form and they said no. I don't have a video of that. I don't have paper to represent that. So we had to have a separate track to determine, you know, how do we have a flat fee payment to somebody who was discriminated against but doesn't have the paper trail, right? And so the estimate was, because they had data, right? They had data on how many farmers in the South in various areas were from different ethnic backgrounds. And so there was an estimate based on data that there would be somewhere between 5,000 and 7,000 claimants in this case. 30,000 claimants later, they realized their data was horrifically wrong because they couldn't really gather appropriate data for people who didn't have paper trails. And there were a great many people who said, you know, look, you know, the reason that I wasn't listed on the registry as a farmer, well, because I had a piece of land and I applied for a farm loan and they didn't even give me the piece of paper. So of course you don't have any record of me. And so we started out by thinking about economic impacts and, you know, working through this entire case. And like I say, Pickford v. Glickman, look it up. It's a fascinating case study. You know, it started as what's called a class action, which means that a similarly situated group, right, which is why you confine it to a certain number of states and a certain ethnic background and a certain, you know, time period. Well, like Spanish farmers and female farmers after the success, you know, there was a Latinx. I don't think they, back then, I don't think they used that term. I think it was called the Hispanic farmers case. They couldn't get their class certified because, as you can imagine, if you try and have a class action where everybody, you know, the defendant says, I want to defend against one thing, not a million things. And so, you know, if you're aggrieved because your Toyota battery blew up and somebody else is aggrieved because, you know, somebody built a construction project for them and it didn't work out. Well, the two of you can't sue the same person together because you have totally different claims. And so the first thing that happens in a class action is you have to create a class narrowly enough that the class is certified, and then that group gets to sue. And when that group sues, then you figure out through allocation who gets what. So, you know, allocations are a big deal. The 9/11 fund distribution was an allocation. When that Amtrak train rolled over in Philadelphia and the government kicked in a certain amount of money and said somebody else divided it up, we were the people dividing it up. And I know the women, the woman that did that, and she said, look, if you were in car one where you witnessed somebody die as a result of the train rollover, you got a different amount of money than if you were in car 7 that didn't even turn over and some people, you know, just shifted a little bit and you got scared. So witnessing death in front of you versus being a little bit shaken up is different amounts of money. But how do you divide that money? So as you can imagine, you know, folks like you were supplying data about what was the earning potential of the person, what was the reduction in earning as a result of this incident. And so figuring out who gets what, you know, the Black farmers case was a massive, massive allocation case. And the data failed us because we started out by thinking there was going to be between 5,000 and 7,000 claimants, and there were 30,000. And so any economic extrapolations that we made turned out to be useless. We anticipated the case was going to take 3 years from inception to closure. And it took exactly 21 years and 9 months to resolve the last little bits of that case. So what was the role of data? It helped and it didn't. Now working on the California fires. Ironically, the town of Paradise burnt down. And so, the other fire nearby was called in the area of Camp. And so it's the campfire in Paradise, right? I mean, talk about like, I mean, there's some weird, ironic, poetic injustice there. It's like there was nothing about it that was like a campfire, and there was nothing about it that's paradisical. It was the largest fire in California history, and now they're giving, we're working out how to take the money from the PGE bankruptcy and distribute it to the claimants appropriately. And the claimants have to come in and prove kind of what they lost. And it's very difficult to say, well, look, I had a really magnificent comic book collection in pristine shape. And you say, great. Did you have a receipt for that or an appraisal? And they said, yes, of course, it was very valuable. And of course I had it appraised. And of course I have the receipt. Okay, where are the comic books? Well, they burnt down. Where's the receipt and the appraisal? It burnt down. So now one of the little simple questions is, you get a different amount of money if you're going to rebuild your home than if you're not going to rebuild your home. Because if your home was damaged, you get the cost of bringing it back to where it was. But if you're not going to rebuild, you have a different calculation of how much damages you're going to get, because maybe, you're not really working on the price of current lumber. For example, if you're rebuilding, then the price of lumber goes up, you deserve a little bit more. If the price of lumber goes down, you get a little less. If you're not going to rebuild, you get a different number. Well, why is this a data question? Because they're ignoring all the data that it's not safe to rebuild in a lot of those places. I mean, the whole system is built around the idea that you might want to rebuild in a place where you probably shouldn't have built in the first place, and then you're going to rebuild back there. And there's kind of government regulation suggesting it's a bad idea. And yet the trustee of the whole thing, it's not, not a JAMS person, but the trustee of the bankruptcy fund, put in place a potential for people to rebuild despite data. All right, so I could talk more about some other cases, but I think I'm going to kind of skip toward the end, because I could just keep giving examples. It's a conflict resolution is a fascinating practice. So those of you who are interested, check out the JAMS website. It's JAMS ADR, which ADR stands for Alternative Dispute Resolution. I like to think that alternative dispute resolution, the settlement of cases outside of court, is really one of the most fertile grounds for socioeconomic practice. And so, my first boss wrote a very famous law review article called Bargaining in the Shadow of the Law. And the idea was that once upon a time, you didn't need to try all your cases because you just found a similar case and you found similar verdicts and you said, look, we could fight it all the way out, but it's going to end up like this, right? And so the law provided data points for would-be settlement. However, now the population has grown, disputes have grown, and the court system has not really grown. And so most trials are criminal trials. And if you want a statistic, a database statistic for the day, 0.6% of all filed civil matters will end with a verdict. So everything in law is either criminal or civil. So most of law is civil. And think about that. Just around 0.5% of cases will end in a verdict. So we don't bargain in the shadow of the law anymore. We simply don't have the data point for comparable cases to say, what's our case worth? Well, let's go look at the jury verdicts. We don't have them. So instead of bargaining in the shadow of the law, now we bargain in the shadow of rumors of other settlements. Oh, I heard a case settled for this. but it was confidential, so we don't really know. But we're going to use that as a reference point. So one of the things that we've seen in my practice is that many cases end where the parties get closer and closer and closer, and then the mediator makes a proposal. And why does a mediator's proposal carry so much weight for people? Because the parties know that the mediator probably has a better sense of the value of the case than anybody else, because they see one case after another and they see those confidential settlements. And while they can't reveal the amounts, they're possessed of sort of the aura of data. All right. So if data doesn't matter the way we hoped it would, if data doesn't control the resolution of disputes, what does? Well, among other things, I would say a set of psychological principles, including confirmation bias, partisan perceptions, the endowment effect, reactive devaluation, loss aversion, status quo bias, and a host of other similarly well-documented, pervasive, predictable departures from the rational economic model. So, I told you I was going to give you the fire drill speech. I gave you the whole long talk, and I'll tell you the fire drill punchline once again. How much does data matter in the settlement of cases? Not as much as I wish were the case. The actual practicalities of interhuman interaction seem to overwhelm people's ability to assimilate all of the data that is available to them. So with that, I promised that I would kind of end my talk somewhere in the 45, around now, so we can start taking questions. And I'm going to do my best not to butcher the pronunciation of your names, and I'll call you in the order that you come up. Edith?
Yes, that's how you pronounce my name. Thank you for that lecture. It was very informative, and I learned a lot. And I was just wondering, why was there a transition to more confidentiality? So at this point, or currently, that you would say something like, we heard about this through the grapevine or something. And in the past, there would actually be documentation and references that you can grab from. So, yeah.
Okay, so why is alternative dispute resolution kind of become a big thing, and why is the court system diminished? In part, there was this, in the 70s, there was this idea of something called the litigation explosion. What happened in the litigation explosion was lawyers were no longer prohibited from advertising, so they could advertise their services. Something called the contingent fee was allowed, where an individual litigant who couldn't afford to sue. So let's just say that a person who's at the lowest economic rung is injured by somebody and they couldn't afford a lawyer. Well, the lawyer could now, as a result of the legal changes in the 70s, the lawyer could represent the client and take a piece of the winning, as opposed to getting paid by the hour. And so that made it possible for people without money to sue who couldn't sue before. Now, in addition, we started to see much more complicated kinds of litigation. Like, there used to not be environmental litigation. There wasn't workplace harassment litigation. So we started to see more and more litigation and more complex litigation at a time when he didn't want to create more judges. And so what happened was the court system got more and more backed up. The US Constitution has a requirement that you can't be held in jail indefinitely waiting for your criminal trial. And so there's a speedy trial rule that prioritizes criminal cases. So what was happening is people who were getting involved in regular disputes in the court system were waiting 10, 15 years to get an outcome, and it was very expensive. And so they started seeking out alternatives. And, JAMS, as I say, we're about 43 years old, and now we've gotten huge. People say, look, if we're going to do a big case, we want a dedicated expert. And by and large, most of the cases that occur outside of court are settled confidentially. Celebrity divorces, the celebrities don't want you to know what their assets are. They don't want that tried in open court. And so basically we move to a system where the court system is overburdened, and most civil cases end up kind of getting settled one way or the other. And almost everybody who settles a case doesn't want it to be known publicly. When dispute resolution wasn't really a known thing and everything had to go to court and courts were fairly efficient, we had verdicts and verdicts and verdicts. Now we don't. Noah.
Hi, thank you so much. And thank you for taking the time to come and speak today. I just had one quick question. So handling a lot of and moderating a lot of like disputes, especially ones on such a large scale, I'm sure you've run into your fair share of conflicts. So what would you say, in your opinion, or ones that you use, what are some effective strategies for conflict resolution or finding a middle ground on a dispute or conflict?
Okay, so I like to boil things down to the simplest possible truths that I can. And when I was teaching in a law school, I knew that some of my people are going to be mediating divorces, some are going to be mediating real estate cases, some are going to be mediating environmental stuff. So what can you say that's true to everybody? Well, the first thing I'd say is there are three essential questions that are really very difficult. They sound very simple, but there are three questions that you should ask in any negotiation, whether it's borrowing the car from your parents or figuring out what major you want to take, or whatever you want to figure out. And those three questions are: what do I want? What's available? And what happens if there's no deal? And so what I want you to envision is that there's sort of one of these scales, one of the little tippy scales where you can put things. And on one side is the status quo. What happens if there's no deal? And on one side is a change from the status quo, the thing you're negotiating for. And what's going to make one heavier than the other? It's going to be your eclectic set of interests and needs. Well, it's very hard to just answer that first question, what do you want? Because what do you want? Well, today you might have asked yourself, what do I want for lunch? And the answer at 8 o'clock might be different than the answer at 10 o'clock. It might be different than the answer at noon when you actually sit down for lunch. And so something as simple as what do I want, changes over time. And there are whole books behind me on choice over time. Then there are interests that we have that we're not proud of. Maybe we want revenge. Maybe we just want to win. Maybe we just want to make a point. There are interests that we have that are conflicting. If you're buying a car and you like red cars and you like blue cars, and you say, well, I don't want a red and blue car, and I don't want a purple car. Maybe you decide for yourself that you don't want to go to the car dealer and say, I like red and I like blue and I'm indecisive. So you pick one, and you basically have limited the bargaining range before you've ever gone and seen what's available. It's like deciding what you want and then shopping for it, as opposed to seeing what's out there and buying the thing that meets your interests the best. People make all kinds of mistakes on those simple questions. What do I want? What's available? What happens if there's no deal? Once you figure out what you want, and then you look to the other side and say, well, what's available is going to be what they want and the things that we can both say yes to. This is now the big secret, not so secret. You're going to find on your lists of wants that you have shared, differing, and conflicting interests. And in every one of those lists, there will be things where your payoff goes up when the other side's payoff goes up. If you're going to buy a car, you don't want to spend 5 days negotiating with the car dealer, and they don't want to spend 5 days negotiating with you. You both have other things you want to do. So efficiency in that transaction is more for one is more for both. So we have shared interests. We also have differing interests. You care deeply about whether you have a red car or a blue car, and the car dealer doesn't care at all. And so the dealer can give you something of value to you that costs them nothing. And then finally, we have conflicting interests. Every dollar you give the car dealer is a dollar you don't get to keep for yourself. And so we have a tug of war where more for one is less than for the other. What we tend to do in American society is turn everything into a dollar and play tug of war. And it's very difficult to resolve conflict if you only focus on conflicting interests. If you really do the hard work to figure out the shared and differing interests, then you can have the possibility of gains from trade. I could talk for semesters about this stuff, but we don't have that time.
Thank you.
Kunal? And did
Thank
I
you,
say
sir.
your
It
name
was a
right?
really, yeah, it was a really interesting talk. I have two questions. So
Okay.
you've worked both in courts and in arbitration. So where did you see data being used more, and where did you see interpersonal factors playing a bigger role?
Okay, well, there's so arbitration generally, at its best, people pick substantive experts who know a lot about their field, and they do that intentionally, and they want that person's undivided attention. So if you're working in an intellectual property dispute over software code related to blockchain, you want somebody who understands all those things. Right. And so you really want somebody with a background in that. And you don't want them to have to say, oh, I've got a million other criminal cases I need to take care of, so we're going to take a break now. Right. So you want a dedicated individual. Now, mostly those individuals with that kind of expertise, they can tell when an argument is good or when it's not. And so sophisticated advocates learn not to try to bamboozle them, not to try to pull the wool over their eyes, because it just makes you look bad. In court, you're either trying a case in front of a judge, or really the reason people go to court is to try a case in front of a jury. And trying a case in front of a jury is a whole theatrical event around persuasion. And the jury kind of knows that they're not going to see all of the evidence, and they don't get to ask questions. So I would say, in an interesting way, the interpersonal dynamics loom much larger in a jury trial than they do in a high-level arbitration. But if you really want to make it extreme, the place where the most fun happens, where the interpersonal side of things is looming most large, is in mediation, where the neutral party doesn't have the authority to impose a result, but merely to conduct a conversation. And what you need is disputing people to say yes. I used to tell my folks in law school, where they said, well, I don't want to be a negotiator. I want to be a trial lawyer, because I want to be like a gladiator. I want to be like a big fighter. And I said, I'll tell you, it is much harder to persuade your adversary of the rightness of your cause than it is to persuade a jury. So if you really want to gladiate, the field is in collaborative dispute resolution. That's where your challenges are the biggest. So I think that's where the interpersonal dynamics are the largest. So did I get most of it?
Yeah, I kind of understood. So basically, you're saying in it's basically the most in mediation, followed by trial courts, followed by arbitration.
I think
And
that's
that's
right.
because
Generally,
that's because people believe the mediator usually.
It's because in a mediation, let's say that you are having a dispute with another person in this class, and as an arbitrator, I get to decide, and you've already agreed that my decision is binding to you. As a mediator, I have no authority to do anything other than say, let's talk about this now. And, but basically you and the other person have to agree. And so really it's about deciding, like, what would be persuasive to them. Maybe they care about dollars. Maybe they care about saving face. Maybe they care about something else, right? Avoiding risk. And so, really that kind of questioning and back and forth to understand deeply the wants of the other side, mediation is the place where that is paramount. Anusha?
Can I just ask a small?
Yeah, go ahead.
So just a small follow-up question. Since you say that mediation works so well, and the person mediating is an expert, and he can figure out what each party wants. He has experience in figuring out what each party wants and is generally good at that. Then why do you also say that you probably want more data to be used? Because according to you, the current system is also working pretty well, where they're using, where they're just,
because I believe in objectivity. I believe that there are, well, there aren't necessarily right answers. Sometimes as between, in a dispute between parents about just how much screen time a child has. The right answer is whatever works in that household with that child, right? And so there's no like single right answer that's universal. But I think that there is scientific information out there that gets ignored, that parents ought to be looking at the effect of a certain amount of screen time or, right? So there is data that should inform those decisions that are ultimately very personal to the individuals. But, I see people kind of guessing and working on instinct. I think that the balance is wrong right now, that a little bit more data would help, as opposed to just making decisions about things based on it feels right. If you think about Blink or thinking fast and slow, we use two different systems to make determinations, rapid cognition and deliberative cognition, and people are much more comfortable turning hard questions into easier questions, and rather than answering the question right, they answer it based on how they feel. And so I wish there were a little bit more reliance on data, not 100%, but more than there is now.
Got it. Thank you very much.
Very welcome. Anusha?
So you mentioned a lot of interdisciplinary studies within dispute resolution, and that includes psychology, economics, law, right? So I was going to ask, in data collection specifically, is dispute resolution more quantitative or qualitative, and how so?
It's more qualitative, and there are efforts in our field that are probably about as old as the American Association of Law Schools has a section on law and socioeconomics. It's probably, I'm guessing now, about 25 years old. I would say the efforts to use empirical data in the resolution of legal disputes has probably enjoyed a focus for about 25 years. But what's interesting is that you kind of have to convene people and very deliberately force that lens onto people, because they're just much more comfortable with a qualitative approach. There's a sense that even the largest disputes that involve mass numbers of people are ultimately resolved based on political considerations, which is like gut feeling. I mean, do we really know what we need to know about voting fraud and whether the changes in voting rules will reduce a problem? Like, so is there a problem? Well, hard to know, I mean, I read a lot of stuff that says the number of actual instances of fraud is vanishingly small, but that doesn't seem to be persuasive to people. Figuring out COVID protocols, you could talk about hospitalization rates and vaccination rates, and you can draw lines, and that doesn't really seem to change behavior. So I think that there's a lot of people who would love to see the decisions be made based on right answers, in the same way that as a child I loved math because they were right answers. There are a lot of people who get involved in dispute resolution because they say, wouldn't it be nice if there was some objective reality that we could point to that would resolve the dispute for us? And so there's efforts to try to find those things. And, those folks are, I don't want to say they're Sisyphus pushing a rock up a hill, but, they are definitely swimming against an inertial tide of gut feelings. And not all disputes are the same. There are sometimes, like an intellectual property dispute where you're trying to determine the stream of profits that came out of a unlicensed borrowing of source code. Some of that stuff can be done with forensic accounting, and you can figure out kind of what the values are on things. But qualitative versus quantitative, no question, we're still in a qualitative world. Rachel.
Thank you so much for speaking with us today. I was wondering how the hiring process works for like an alternative conflict resolution service, and that like when you have two lawyers in a normal court case, each person knows that their lawyer is representing just their interests because they're paying them. So how does it work for you guys when you have one service kind of helping two people negotiate the settlement?
Okay, well, so arbitration and mediation are very different. Those are the two dominant kinds of services that we provide. It's not, those aren't the only services, but arbitration is a creature of contract. You can't be forced to be bound by the decision of a third party neutral or panel of neutrals unless you've agreed to do that. And so you either agree to do that by signing a contract, and sometimes actually all of you are bound by arbitration clause and guarantee. If you have a smartphone, there's no question that somewhere in your smartphone contract, you have waived the right to sue and you'll go to arbitration. And so there's a contract, and the contract usually requires the parties to that contract to go to a named or a named dispute resolution service provider. And so maybe they've written JAMS into their contract or a different service provider. So when a dispute arises, you automatically already have a contractual provision that brings you into an arbitration. And then there are various mechanisms for choosing arbitrators. Like there is often what they call strike lists, where, if we can send out lists of 7, each side knocks off 3, and then the remaining one is your arbitrator. So there's various ways to choose an arbitrator. There's also rules that if you can't choose, you can go to court, and a court will appoint an arbitrator. On the mediation side, they generally, it's parties agree to pick select a person. And then they come to us and they call and say, hey, is Rich Birke available? And so it's generally reputation. It's pretty rare they call and say, we just want a mediator. Do you have one around? They usually have a person in mind, and often that person is known in that subdiscipline or that geographic area, and the lawyers just agree. And then our job is to maintain very strict neutrality so that nobody has any argument that we tipped the balance in one direction or another. So that's typically how it comes in, is agreement between the parties. And when I say the parties, 99% of the people who hire us are the lawyers representing the parties. So the lawyers know us. And of our 450 mediators, 300 of them are retired judges. So they were well known in their communities. Anand?
Thank you so much for providing the opportunity. How much do you think that the big role data plays in this alternative dispute resolution, and how do you think that what role that having more data can affect the decision, or maybe social instincts can affect?
All right, so when we talk about dispute resolution, we're talking about a vast field, right? And so an antitrust dispute where Apple and Samsung are alleged to have colluded with each other, and the government is suing them to prevent that kind of collusion. It's going to be a very different kind of dispute than husband and wife are divorcing and they have kids, and who's going to spend how much time with the kid, right? And so when you look at the array of things that people can fight about, it's a very vast array. Some of it's more amenable to data gathering and data analysis than others. So if a family is basically trying to figure out after a divorce, how much will the higher earning spouse pay to the lower earning spouse? Well, there's really not objective data there to say what the right number is. It's like what works in that family dynamic. If mom is going to post-divorce move from New York City to Kansas, and the cost of living is going to go down dramatically. I mean, I guess you could look at sort of CPI and, you know, consumer price indexes through the two places and make some determinations. Whereas if what you're resolving is what kind of fix is it going to take to fix some kind of building that's gone wrong. Those of you who are in New York, one of my buddies is working on the new subway lines. And I'll tell you, you know, you don't put in a new subway line in New York without there being some conflicts. So there is data, like how much is the price of steel? How much will it cost to repair a certain structure? Well, so I'm just going to say, in the wide world of disputes, there's an equally wide distribution in terms of what data are available and what data are instrumental in resolving the problem. A big part of this is who gets to make the ultimate call? Is this a government official invested with kind of answering for, did they have an objective reality for how they made their decision? Or is it just going to be a couple of parents who whatever worked out between them is fine and nobody's going to know? So, you know, it sort of maps onto particular conflicts differently. And I will say some are higher data than others, and some are pretty much zero data. Unfortunately, when we get to situations where there's too much data, the people who are generally the investors or the company owners, they can't even figure out how to deal with that much data. So when there's too much data, it's almost like there's none. But it varies depending on the context. Burton Alexander.
Hi, thank you so much for speaking. My question is, when you're settling a dispute, what do you do when both sides have conflicting data?
Oh, they usually do. We often have these battles of experts. And there's a new thing. So typically everybody can find an expert to say whatever they want. Right. I mean, that's, you know, it's unfortunate, but, you know, if you want to prove that a design from an individual made its way into a Nike product, and the person doing the design wants to bring in experts to talk about the uniqueness of the color palette, the uniqueness, you know, right? They're going to have an expert to say nothing like this ever existed. And then Nike's going to be able to get an expert to say completely, you know, that this was, everybody understood this and it's not something you could have a copyright or a patent for. Software, you know, you can always have, basically you can always have experts on each side of an equation. My first job when I was working at Stanford, Bob Mnookin was doing the IBM Fujitsu case. And the allegation was that Fujitsu had stolen a piece of IBM source code and was basically profiting on its computers based on something that they never should have had in the first place. And so they had forensic experts determining how much of Fujitsu's profits each year emerged out of this particular piece of source code, without getting to the question of whether it was a product of theft or not, but they could at least trace from the piece of source code out to profits, and then they could figure out how to divide those. I've gotten a little bit far afield from your question. Can you remind me?
Yeah, like how do you deal with data that's conflicting?
Oh, conflicting data. Well, ultimately, people, the way most disputes resolve is people get close enough that then the costs of fighting it out aren't gonna be, it's not a sensible economic investment. Like if you start out asking for $1 billion and the other side offers you zero, and at some point you get to the point where you're now $500 apart, well, you're going to pay your lawyers $500 an hour and you're not going to get closer. And so you end up bridging gaps based on all, you know, different perceptions where you say, it's just going to cost too much to reconcile our perception. And so we're just better off making a gut level decision to be somewhere in the middle. And it's a good financial decision because once you know that it's going to cost more to get the answer than the value of the answer, that's usually how we end up resolving data conflicts. There's an interesting thing now, phenomenon that's been emerging in the last probably 3 or 4 years that we call hot tubbing experts. So instead of bringing in plaintiff's expert to talk about why plaintiff should win, and then later defense experts talk about why defendant should win, and they each talk about why the other side is wrong, you bring the experts in at the same time into your arbitration or your court proceeding, and you say, so you two battle it out in front of us. And we find that the experts often shed some of their partisan skin and just work on the problem. And so that's a way that helps resolve some data disputes, is this so-called hot tubbing of experts. But usually disputes get resolved despite, not because of despite differences in data, not because those differences have been reconciled.
Okay, thank you.
Lujane, and I bet I didn't pronounce that right.
Oh, it's all right. It's Lujane, but I don't mind anything. Okay, so thank you so much for speaking to us today. So I'm also a big believer in objectivity when it comes to decision making. And you talked a lot about having a large amount of data and how that it makes it difficult to make a decision. However, I was thinking on the flip side, when there's not enough data to support either side of an argument, how do you think what's the right course of action to still have an objective decision taken at the end?
Oh, gosh. Well, once again, we get to the point of who owns the solution, right? And who are the stakeholders to a problem? If this is you and your roommate deciding what the right hour is to be quiet and shut the lights out in the night in your roommate, in your dorm, I don't know that there's an objective answer there, right? It's what works for the two of you. And if you want the lights out early and you present data that say a certain amount of sleep for people our age is correlated with higher GPAs and higher, whatever, right? They might come back with other data. And sometimes you argue about, well, what is the right data? And, you could spend the rest of the semester kind of figuring out what data you were going to use. And by the time you figure it out, you're not roommates anymore. And so, you really need to look and say, who owns the problem? Who is going to be the consequence of this? Now, it may be different if it's the university trying to decide what time quiet hours are going to be, right? Because they're going to be deciding it not just for an eclectic set of roommates who may come up with a different regime. They're trying to create something that's going to be of lasting value for everybody in the college. And so, the first question is this a topic that is amenable to data analysis? And if so, what data do we need and how long is it going to take to gather that data? And, it really means that the stakeholders have to reconcile whatever differences they have in order to determine a path for gathering data and the value that that data is going to have on the ultimate decision. So sometimes the result of a mediation is to come up with an algorithm that people can use to resolve a conflict, to say, okay, we're going to now gather the following data and it will provide an answer. But, really, I think we all know the measure of the data that you choose will often be outcome predictive. And so whether you're choosing, say, cost of living index in your neighborhood, in your city, in your state, or in your region, will produce 4 different numbers. And so you can say CPI is objective consumer price index, but now you have arguments about which consumer price index. So where there's a lack of data, as long as you have decision makers that are committed to making a decision based on some data, and they can come up with an algorithm for finding that data, then you have a data-driven decision. But I'm sort of a Kahneman Tversky adherent to, in that I believe that even when people believe that they are making objective decisions about process, that they are somehow unable to choose objectively. They choose strategically based on their background, their interests. I mean, they bring their humanity to the table, even when they're trying to be objective. The data that they emphasize will be chosen subjectively.
Thank you for your answer.
Okay. All right, last question, Pratik.
Thank you, sir. I really appreciated your speech, and it sparked my curiosity about one thing. Like, how much computerization have you seen with your field, and what computer programs do you use or your team uses on a day-to-day basis for processing all that immense amount of data?
Okay, well, we don't. So let's just start there. We do not have programs that we use to process data. So usually, if there will be such a program, it's brought in by the clients, and they'll, and they often have. If they found some kind of objective computer-based way to resolve a problem, they don't come to us because they've done it on their own. There are people who are trying to use algorithmic computer programs and AI to resolve certain kinds of disputes that happen over and over again. And so, for example, a guy named Colin Rule, R-U-L-E, was in charge of dispute resolution at eBay. And, if the buyer and seller at eBay have a dispute about whether the purchase product was the same as what was advertised, and if there's a disparity in value, how that's going to be resolved. Well, it turns out that there are so many eBay disputes that there is now a predictive computer algorithm that eBay uses to kind of tell you where they think it's going to end up. And so they can't force you into accepting that. So it doesn't provide an answer, but it provides a focal point, a target. So I think if you want to look at the places where algorithms and computer programs and AI have started to encroach upon the work of human mediators and arbitrators, it's going to be in small commercial transactions like eBay and Amazon. That's the place where you're going to find most of the action. And of course, they're keeping that stuff super proprietary because they don't want competitors to know what they're doing, and they don't want critics to be able to come in and effectively critique the effectiveness of the program that they're putting into place. So I think that there's potentially some room ahead, but AI is only as good as the programmers who create it, and so I think it's still, at least in my lifetime, maybe not yours, but in my lifetime, I think it's going to be still consigned to the realm of subjectivity. Okay, so closing comments from our hosts.
Thank you so much for coming today, and I really appreciate all the time that you took to answer everyone's questions. I know that everyone here has a lot to say about what they learned and what they were able to take away from this. Without further ado, please raise your, Zoom applause, and thank you so much for coming.
My pleasure. Thank you. Thank you for inviting me.
All right. And it went really, really well. And it was fun and engaging. And thank you for making it as interactive as possible. And yeah, and you're free to go. But right now, we're going to begin presenting a little bit more about the program since it's their orientation. So we thank you so much once again.
All right. Thanks, everybody. Have a great day.
All right, awesome. So today what we're going to be doing is just having a pretty light day. This is essentially you just getting to know about us, and then we're going to send out a form today after this meeting where you could actually choose your projects and also confirm that you'll be part of this fellowship. We're going to go over some expectations, some really cool stuff that we'll be doing, and so on. So it should be really fun, pretty easy, light day. You're gonna get to know each other later on. If you're having trouble downloading JASP, downloading our studio, or any of the programs that we gave you, we'll have a quick session where you can meet up with the TA and they will assist you in downloading it. I know that most of the issues include which CRAN mirror should I download? That should be pretty easy. You could pick the one that matches your country and you could just pick any of them. Other questions are, I can't download RStudio because my computer doesn't allow me to because it's an older computer. In that case, you would use RStudio Cloud. And that's a great feature that you could just do on a browser on essentially any device. All right, so with that being said, you will also be able to